Okie dokie, ready when you are. Counsel?
Good
Good
afternoon, Your Honor.
afternoon, Mr. Lowe.
Good
Hello.
afternoon, Your
Ready,
Honor.
Mrs. Ziner? When you're ready, Ms. Clifton.
This is case number 24009097 in Accurate Care LLC, LaDaniel Miller versus Progressive Marathon Insurance Company.
Counsel,
Good
please.
afternoon. Good afternoon, Your Honor. Jamie Lund, on behalf of the plaintiff.
Good afternoon, Your Honor. Daniel Zittner on behalf of the defendant, Progressive.
Okay, Ms. Ziner, this is Progressive's motion for summary disposition relative to neuromatrix. You may begin.
Thank you, Your Honor. As you said, this is our motion with respect to summary disposition for these neuromatrix charges from plaintiff. As we've detailed in our motion, Crone v. Homeowners, which is a Supreme Court case, says that the plaintiff bears the burden of showing that an experimental treatment is reimbursable. Now, the way that they do that is by showing that the treatment is efficacious, and the way that they're able to do so is by providing objective and verifiable medical evidence of the same. Now, in this case, plaintiff has failed to do so, and defendant, through its burden through MCR 2.116C10, has provided information that shows that this neural matrix treatment is not efficacious. I believe in our motion, exhibits P, Q, and R, we provide opinions from various doctors showing that it's not efficacious. We have deposition testimony also included in our motion, and plaintiff has failed to provide any sort of evidence refuting what defendant has provided in this case to show that this neural matrix treatment is indeed efficacious and therefore reimbursable under the No Fault Act. So respectfully, today we would just request that you grant our motion with respect to these TPII or neural matrix treatments.
Mr. Lowe?
So the deposition testimony that defendant cites to is not admissible in this case. You can only attach or use deposition testimony from other cases when the witness is unavailable. That's first and foremost. Secondly, we've attached about 100 pages of medical journal articles, which are peer reviewed, that show that this is efficacious. The neuromatrix treatment is basically a more focused version of a TENS unit, and TENS unit has always been compensable underneath the No Fault Act. So at this stage, when you have to take the facts in the light most favorable to the non-moving party, and having attached about 100 pages of journal articles showing the efficaciousness of the treatment, I think that the court has to at least find a genuine issue of material fact here.
Ms. Ziner?
Yeah,
Respond.
Your Honor, I just want to mention that if you actually look through plaintiff's response, there's actually in any of those exhibits that they've attached, there's no mention of the neural matrix device anywhere in those exhibits, except for one that tries to contend that because it has FDA approval, that shows that it is efficacious. Now, the FDA approval in neural matrix application it did not include any sort of imaging or mapping for these trigger points. It's simply for marketing this device into the stream of commerce. So respectfully, Your Honor, with that information, plaintiff's evidence still fails to generate a issue of material fact, and defendant's motion is still properly granted in this case. So we're still respectfully requesting that the court, based on the arguments, briefs, response, grant our motion today.
And this isn't the court's first experience with the neuromatrix machine. We've gone back and forth on several occasions, and the court always maintains the same position. In terms of determining the efficacious, whether or not it's the efficacy of it, as has been indicated, there's not or very little, if any, evidence that proves its efficacy as it relates to image image matching in terms of the services that are rendered here. And that being said, the court has always granted the motion for summary disposition in that the court doesn't find that the plaintiff has bared out the burden of proving that this nerval matrix machine is efficacious for the reasons that it's set forth and the uses that it's set forth under the no-fault statute. Granted, it may have FDA approval, but it's not relative to what's being sought here and in the no-fault cases. Therefore, the court will grant the motion for summary disposition. Mr. Zender, you can prepare an order presented to entry for the court. And I believe, is that the only thing that's uh,
Your
the
Honor,
charges?
yeah, I believe we also have a settlement conference today as well.
Okay. All right. So, Ms. Clifton will give you an invitation to a breakout room, and then I'll join you shortly.
Okay.
Thank you, Your Honor.
Thank you. Okay. Let's do the other SD, and then I'll join them.
Okay.
Good afternoon, Council.
Ready, Judge?
Good
Good
afternoon, Judge.
afternoon, Your Honor.
Ms. Clifton.
229. This is case number 24012014 NF. Neil Malahi versus Progressive Marathon Insurance Company.
Council appearances for the record.
Good afternoon, Your Honor. John Callahan appearing on behalf of the plaintiff.
Good afternoon, Judge Ross Brunetti appearing on behalf of Defendant Progressive in the stead of Attorney of Record Lauren Johnson.
Okay, and this is Progressive's motion for summary disposition.
Your Honor, before we get started, I was supposed to tell you something. Ms. Groves was supposed to cover this afternoon,
Okay.
and she had another conflict, so she apologizes for not being there. She was looking forward to seeing you today.
Oh, okay. All right. Thank you. Okay. But you're standing here in her stead, Mr. Callahan.
I am in her stead today.
Okay. Thank you, Mr. Brunetti.
Yes, Judge, this is defendant's motion for partial summary disposition. I feel like Ms. Johnson did a nice job briefing the issue. I'll try to narrow the issue for the purposes of oral argument. Essentially at issue are PRP injections and bone marrow aspiration treatment provided by the plaintiff. It's defendant's position that these services are contemplated by Medicare. Payment amounts are provided by Medicare. And as such, the Michigan No Fault Act requires that plaintiff is limited to 190% of whatever the allowable charges are by Medicare. And further, that that position is interpreted by Central Home Healthcare. The opinion cited in Ms. Johnson's brief is also being subject to modifications and limitations related to the amount allowed by geographic location. And again, Medicare provides for geographic modifiers for these treatments under the CPT codes that they provide payment for. I am not aware of any case law or statutory authority that allows for the proposition that if a plaintiff medical provider asserts that they happen to provide this treatment better than anyone else or under a quote unquote higher standard, that they are somehow exempt from having to comply with the No Fault Act or the case law interpreting said act. My opinion is that's effectively what plaintiff is asking you to do. Again, our position is that Medicare allows for payment of these services, PRP injections and bone marrow aspiration under specific CPT codes. And it doesn't appear that plaintiff is denying that what they provided were PRP injections or bone marrow aspiration. And for those reasons, I'd ask that you grant our motion for summary disposition and order the relief requested in the brief, Judge.
Okay. Thank you. Mr. Callahan.
Your Honor, what this case is going to eventually come down to is going to be the experts, at least with respect to billing. And from what I've seen with these particular motions, we did attach the report from our billing expert. He goes into great depth explaining how the procedure that is performed at Specialty and Universal, the plaintiffs, is remarkably different than the procedure contemplated by the CPT code. The CPT code contemplates a very small amount of blood being taken. It's usually processed off-site, and then it's a single injection back into the patient with the blood product that's produced after it's prepared. Our process takes approximately 6 hours, where we take 5 and sometimes 10 times the amount of blood. We prepare 10 times the amount of blood product to be injected back in. And this isn't a single injection, it's multiple injections over multiple areas with signs of objective injury. With respect to the bone marrow aspirate, the charge for bone marrow aspiration, I believe, is just for aspirating bone marrow. It has nothing to do with the preparation of the bone marrow, the re-implantation of the bone marrow into areas where this type of therapy is necessary. And to try to compare these procedures done by my client's facility to the procedures outlined by the CPT code and what's contemplated, they're apples and oranges. They're two different procedures.
Okay, this is my thought. If is that something that's even covered? We might need a different motion. If you're saying that this is something that's not contemplated by the CPT codes, is this something that, and I don't know how long your client's been doing, is this the efficacy nature of it? Has that been provided? If you're talking about something
Your
different,
Honor,
so I'm saying, is this
I've
a different motion that it's not
I've
even?
argued the efficacy motion with respect to these exact procedures for these clients. And I can tell you with respect to PRP and the bone marrow, I have never lost an efficacy motion. There is so much research out there these days that my client, as well as other practitioners, rely upon. All you have to do is Google it, and 50 articles will come up showing efficacy.
Okay, but though, so we got past that, but then why should your client get something other than that which is contemplated by Medicare and the no fault statute? You know, that's it, because you're saying everything you do, but the Medicare, you use the CPT code, you get paid by the CPT code. If you think you should be get paid something else, then maybe you should submit something else and we'll see, and maybe that's another argument for another day. But if you're using this CPT code, that you get what the Medicare allots in the
You,
190% of the allowable Medicare expenses.
Your Honor, we've never used a CPT code utilized by Medicare. We've always billed it out under the 20999, which basically indicates that the the procedure is, and I can't recall exactly the language it's like an unnamed procedure, because we've never billed under the Medicaid procedures, because it's a different procedure that's being performed.
Mr. Burnett, you were getting ready to say something on this issue?
Yes, Judge. I was just going to say, my read on it is it looks like an apple. They're calling it an apple. And when I say that, they're calling it a PRP injection or bone marrow aspiration, which again are contemplated by Medicare, but they're asking you to let them treat it like an orange. So they're trying to thread the needle here. They're trying to say, we want to call it this thing which is contemplated by Medicare, but we want to tell you that we do it so differently that it should be treated differently. When I don't know, everything else, the procedure, what they call it, everything else, it's a PRP injection and it's a bone marrow aspiration. If that's what it is, then you're limited by Medicare. They're asking you to find that they're special or they're different because of the way that they do it, when in fact Medicare already contemplates and only allows X amount for these procedures. That's my
Okay.
position, Judge.
What about the fact that they're saying that we didn't bill it under the CPT code, we built it under this 20999?
Right, because they're trying to get out from under the CPT codes that are contemplated by Medicare. They're calling it an apple, but they want you to treat it like an orange again. They're calling it a PRP injection. They're calling it a bone marrow aspiration, but they're asking you to treat it differently. If it's something different, I don't know. Maybe it should be called something different. But the bottom line is they're representing it as a PRP injection and a bone marrow aspiration. Now, if they want to, say that they do it to a higher standard, that's fine. That doesn't mean you get paid more than anybody else.
Mm-hmm. And like, and Mr. Callahan, is it anything other than a PRP injection or bone marrow?
It's not the
Okay,
PRP and bone marrow contemplated by Medicare.
but it's a PRP and bone marrow aspiration, right? That's what you all, the description of it is,
It's
even though you may use 20999, what you have articulated, let me see, where's the bill? Is a bone marrow aspiration and a PRP injection.
Our bone marrow aspiration also includes therapy where the aspirin is put back into the patient. The bone marrow aspiration contemplated by Medicare is just taking a bone marrow sample and then using it for diagnosis or for to try to essentially diagnose what's going on with the bone marrow.
Okay, but that's what I'm saying. If it's something else, then, you call it something else and then it won't be covered by, Medicare. Then, you're saying that you you've prevailed on the efficacy nature of it, but the bottom line is still what you've called it here is a PRP injection and bone marrow aspiration with a twist. That's basically what it is. And if the twist doesn't necessarily grant you a payment though, anything other than that which is set forth by Medicare and the 190% of the allowable Medicare charges. So, taking evidence like most favorable to the non-moving party, the court finds that even though it's coined as a PRP injection and bone marrow aspiration, however, plaintiff asserts it is done with a twist, but that's not what's covered here. It's what the Medicare and the no-fault statute contemplates is the coverage of Medicare and 190% of the allowable expenses for the PRP and bone marrow aspiration. If the plaintiff is doing something else, then I don't know, but when you call it a bone marrow aspiration and PRP injection, that's what you get paid for, and the court is going to grant the relief and order that the limit that is allowable here is the 190% of the Medicare allowable charges.
Thank you, Judge.
Okay, you can prepare an order, Mr. Bernetti, and present it to the court for entry.
Thank you, Judge. Everyone have a great afternoon.
You as well. Thank you.